Got to check in agencies.
Okay, we're back. Recording, fine? Okay. Just one item, and Laura actually just requested that the board consider delegating authority to the executive officer to make any additional changes that are consistent with changes that the board made to the regulations today. So like if we miss something in the regulations that causes an inconsistency between two sections, so that the language can be consistent.
Yeah, and that so then she would be able to make that change.
I'll make that motion if you need it as a motion.
Thank
Yes.
you, Stan. Second by Victor. Okay, any public comment? All those in favor?
Aye.
Okay, moving on to item 8, discussion and consideration of proposed regulations to amend Title 16 CCR Section 1732.05, 1732.2, and 1732.5 related to continuing education. So this is a regulation that the board has reviewed before. And most recently, at the July board meeting, the board discussed and recommended consolidating the 6 subject areas into the board-approved CE course. Remember, we used to have them that they were required to take CE in certain areas like emergency preparedness, sterile compounding. At the last,
Right.
well, it was, I thought it was the board, it says here, the board approved a modified text
Right.
and initiated a 15-day comment period. What we did is we made the change so that there's a CE course now in law and ethics. Remember, we discussed the board staff doing the CE and all of that. The 15-day comment period began on August 3rd, 2016, and ended on August 18th. The board received one comment during the 15-day comment period. And that one comment, it doesn't say who this is from, Lori. Is it anonymous? Yes. Okay, the anonymous comment is there should be no board-approved CE requirement at all.
Provided.
Provided CE requirement at all. All CE should be ACP accredited, and the pharmacist allowed the flexibility to choose among any general CEs that would meet the requirement for license renewal. This is an outrage to mandate pharmacists to take board-provided CEs when pharmacists are licensed in multiple states.
Wait, sign Stan Weiser.
Wait. Well, the other
I did not write it, but I must admit it does
It has that
verbalize some of
ring
my
of truth.
I'm
thoughts.
just watching that smile get bigger.
the other issue is, if it's board provided, is there gonna be a charge?
And I guess the other question I have too, Jenny, is what happens to pharmacists that reside in Washington?
We will have at least a video form and possibly a webinar form and a CE form perhaps in the newsletter. So we'll have various,
So do we have resources for this?
we do it now. This will just be focused on a single
So
topic.
these are free, provided by the board.
Right now, we're doing them free.
Okay.
Okay.
I usually end up doing, Ann and I just did two actually, and I've got about another 3 scheduled in the next 30 days. It's just one of those things that I think it's important we do. And then that doesn't include the inspectors who go out,
Because we don't
and
want-
they're
we don't
better
wanna be in
placed to do this than I
competition
am.
with those out there who are.
And we
providing
have
it.
webinar capability for these, because my concern too is access, making sure the pharmacists have access to this. Is it going to be sufficient webinar? Is it on demand? How are we going to do this?
Well, the webinar would be more on demand, but we could put it online. I mean, there's various ways we could do certain things that would be available. We'll just explore the
We
options.
could do a
little bit.
YouTube.
We could do that too.
Yeah.
And we have Cesar, where is he? We could have him film us.
Perfect.
But this is an opportunity for us to do some different kinds of technology-related things that we're not doing now. So it's a wonderful opportunity for us. And we don't want people to have to, I mean, if they want to come to California, fine, but we don't want to burden them with having to come to California.
Okay.
But we do allow all the leeway for pharmacists to take whatever they want out of the ACP accredited classes. And this is only something that we want them to comply, is to know what's current in California and what are big issues in California. So every 2 years is really not that much.
Well, the course will change
It's 2
every year.
hours.
The
Just do
intent
2
is to
hours.
change it every year so that it stays to reflect the current new law.
Because they renew the license every 2 years.
Yeah, but they only have to do it once. They don't have to do it
They don't
twice.
have to do it once.
But it may be so good, they're going to want to do it a second time.
Debbie's got a motion.
I've got a motion to adopt the regulatory language as approved on July 27, 2016, and delegate it to the executive officer. The authority to make technical or non-substantive changes as may be required by the Office of Administrative Law or the Department of Consumer Affairs to complete the rulemaking file.
Second by Ricardo. You saw her clap her hands, right? Public comment.
Sorry. And good afternoon, Brian Warren with the California Pharmacists Association. I feel that we feel that it should just be the continuing education in law and ethics and not necessarily board provided. Part of the reason for that is that pharmacists already take law and ethics CE in a number of venues throughout the state, and that should apply towards this, unless the board specifically thinks that there's certain areas of law and ethics that are not being provided that it wants to provide. I don't see the justification for not giving credit to pharmacists
I
who've
think-
taken CE.
From what I recall from our discussion, Brian, I think the focus was that there's new regulations that we're issuing. Sometimes the pharmacists don't understand them, or they're not compliant, or maybe there's a regulation that we're finding that that pharmacists are having issues with. And this gives us an opportunity to do some education on those targeted areas.
Okay.
Ginny, is that right?
Yes.
Um,
Very good.
So then I think it was mentioned, I understand, providing new webinar-based or video-based CE, as well as the ones that I know that Ms. Harold has spoken at some of our events before as well. But if the board is going around doing in-person things, are they going to get each of those ACPE accredited so that people are getting because
It
when a
may-
board...
Yeah, it may be a good idea to have the licensing committee flesh this out in terms of how it's going to be done and how it's going to be accessed and all of that. That way, they'll give an opportunity to get some input from the public on how this works out. How does that sound?
Yeah, that's okay. Yeah, you want the licensing committee or communication and public ed?
The licensing would be, it's the pleasure of the
Okay.
licensing committee.
Okay,
Okay.
licensing will take it on. So that's a good
I
point,
know,
Brian.
boy, somebody was
I'd like to
hooking
make,
that one.
I'd like to make sure my big issue is making sure they have access to, because if it's just a webinar that
Sorry,
you have to
Stan.
dial in at 2 o'clock on a
sleep
Wednesday, if you're busy, you don't want to have to deal with that.
Okay.
Just quickly, I don't know if I misheard, but I don't think it would need to be ACPE accredited. Did I hear that?
Yeah.
Yeah.
Okay,
Right,
that's
an
sort of,
approved CE provider.
but the
The board
board
can-
can
can approve
approve
CE.
itself. So I don't
Okay.
think you need, if the board is offering
We have
it,
power,
it doesn't
Brian.
need
We
to
have
approve
power.
itself. So, yeah,
I
I
suppose
don't,
my point is just like, if the board is if board staff is doing, making a presentation right now, that may just be an informal presentation that somebody attended and learned something from, but we want to make sure that they can obviously get credit for
That's
that.
why we want the licensing committee to kind of
Okay.
flesh out the details and how this is going to work so that we do this the right way.
right.
But I do usually a law review with CPHA and then one in the fall with CSHP. It's pretty normal. And I think that the one I do at CPHA is, I think, a unit and a half. And CSHP's, I think, is only 1 unit. They only give me an hour.
Perhaps. Right.
No,
Thanks, Brian.
I think it's an hour and a half, I know.
You want 2 hours now? You want
No.
2 hours now?
No, nobody wants to hear me talk for 2 hours.
Steve Gray from Kaiser Permanente, but really speaking as an individual, I had the pleasure, I think this is the right direction, first of all, and I applaud you for going in this direction of law and ethics and making it 2 hours instead of the ambiguous 6 hours of 6 different subjects. But last October, there was a special meeting convened by ACPE in Chicago that talked about completely revising the standards for pharmacist continuing education. And a lot of data was presented at that meeting showing that unless there was active learning in the session, then there wasn't much value in the CE. And in fact, 80% of the CE by pharmacists was considered of little or no value. In fact, they couldn't even document well that the pharmacist had actually participated. I mean, you can sign up for a webinar and be watching television at the same time. You can get answer sheets for journals where you have to answer a test, but the answer sheets are spread around. And the feeling with that meeting was that 60 to 80% of the CE across the country approved by ACPE was in that category. And so that's why they now have standards in the live CE or even in webinars for active learning of some type, where they try to have a discussion. I'm not saying that it works out well. I've attended some recently where they try to ask questions of an audience of 500 and maybe, answer A, B, or C on the screen, and they call that active participation. So I think when the licensing committee does work on this, they need to talk about what are the standards by which this board-provided continuing education are going to meet. Are they going to be similar to what ACPE has or what the board expects out of the California, the CAPE organization? Are there going to be learning objectives? Are there going to be a self-assessment, post-assessment? Is all of that going to be up to the same standard as that would be required for CE credit from the Board of Pharmacy by either ACPE or CAPE, the two that outside the board's own staff are recognized by the California Board of Pharmacy. So I think if it's the Board of Pharmacy presenting it as a substitute for some of that, then I think really need to talk about what standards. I don't think that informal presentations by a board inspector who happens to be attending a meeting, unless well prepared and meeting certain standards, is really going to do what the board really wants and needs to have done. I cannot overstress, pardon me, the need for that interaction, because that's where you really find out whether they really understand what you want them to understand or not, rather than just presenting it. If it was just presenting it, you could just force them to read the newsletter, but that isn't working. And so I encourage you to really get into what are the standards if the board is going to provide the CE. Thank you.
It seems through all levels of education, including universities, learning outcomes is something that they're trying to figure out how to assess. It's not something that can easily be done regardless, and I would imagine in particular if we're talking about continuing education. WASC and everybody else, that when they accredit different institutions now are asking that the institutions figure out how to assess learning outcomes. Very, very difficult process, maybe more of a process than what the Board of Pharmacy has the broad capabilities to do.
Yeah, and it's only 2 hours out of the 30, but we may have some of the pharmacy schools maybe come to the licensing committee and provide some
Yeah,
input.
that'd be good.
Okay, so we have a motion, second. All in favor? All right, so Christine, you're up. Sterile compounding. So good news, our sterile compounding regulations were approved, and they are now, they were officially approved by OAL. They go into effect on January 1st, 2017. So since that is right around the corner, we are going to be discussing today a waiver process for hospitals and pharmacies that cannot complete. And I think there's a waiver provision inside in the regulations that allows, and I think there's some slides in here. Are these your slides, Christine?
Actually,
Yeah.
those are my slides. That's what I provided at the Enforcement Committee as a draft. So what Christine and I have done is develop a more standard form package that looks a little more like that. And then I have a meeting tomorrow with Laura and we'll finalize it.
Do we have copies of that?
I don't have copies to distribute because I
What-
want legal to review it
What
first.
I would recommend, if there's a way, and again, Laura, maybe we could do this as an example or a sample, but it would be easier from a review process and from a stakeholder process to have some type of standardized form that we could fill out. And they don't have to use it, because if it's not in the reg, we can't force them to. But we could suggest it just to make it easier for everyone to review actually what is required, to make sure they've crossed off all the boxes.
Well, Christine has also developed a log to track things too.
So if I understand this correctly, at least this is what I'm doing in my organization, is we are doing a gap analysis right now to see what it is between what we have now versus what we're going to expect to have in place by January 1st, and then get ready to submit a waiver request, if necessary, to the board in January. Is that what the recommended actions right now are from our inspector staff?
So right now, when we're getting, says on.
You want to introduce yourself, Christine?
Oh, it's working? Okay, Christine Acosta, Supervising Inspector for the board. Right now, the many questions, emails that were coming in, I've been providing people, hopefully would get more clarity out of today exactly what you guys expect from us. But I've been collecting names, license numbers, basically people that want the information, have already asked for it. I will give them that information. Absolutely, people should be looking at a gap analysis. That's one of the reasons why the self-assessment went out in the draft form, because it's a good tool to help them see where you need to be versus where you are. But right now, we're not accepting waivers, nor
But the
do they
waiver,
really
just to
know.
clarify, the waiver is only for the physical changes. So the gap analysis should be for everything, but the waiver request can only be for physical changes. I can't say,
Correct.
I can't get my training done, so I need a waiver.
Correct. It's
Okay.
only going to be for things that require physical changes in the physical plant.
Good.
And
Can't be a-
time, it's delay.
It's, yeah, delay in compliance. The waiver will allow a delay in compliance to get your facility where it needs to be.
Could there be anything that would be other than physical construction that could be a legitimate reason for having to get a waiver or having to get additional time?
I don't think the way that the law was written would allow the board to approve a waiver that's not for construction. So I would refer back to our legal counsel over here, but my understanding and my read of it is that we couldn't, even if there was a good reason.
I think part of this too, Greg, when we talked about this, is that the draft regs have been out there for a year. There's been plenty of time, and I know that there was some discussion at the enforcement committee that, oh, we don't know what the final regs are going to be issued, but they've been out there. I know that the inspectors, as Christine mentioned at their enforcement committee, has been going around and advising and educating pharmacies when they do sterile compounding inspections, which they have to do annually, to get them ready to go. So I don't think any of this is any surprise to anyone.
Well, but if you're, let's say you're a real large company or firm, and you have to. Let's say that you happen to be a real large operation, and you need to spend a lot of time in training and, you know, educating your people to get them ready to go. And, you know, what if it's going to take longer than January 1st? Just wondering.
You're going to request a longer time, and then part of that is, if you're a large institution, you have to go to the Office of Statewide Health Planning.
Uh-huh.
And there you have to file some forms, and there's a whole process there, and we're tapping into that as part of the monitoring of the waivers.
Okay, so-
He's saying that if they needed
They're so
longer
big.
just for training, not for
Oh,
physical.
I'm sorry,
They
just,
can't get all their people trained.
that, you better start now then, don't wait till
Okay,
January.
but are there any other types of things that could slow somebody down other than physical construction, where they would need to get some type of a, you know, deferred situation?
Typically, when we implement a major new reg like this, there's a period of educational compliance. Now, I understand from Dr. Acosta, for the last year, we have been training during our annual inspections of sterile compounding pharmacies to compliance for our new regs. So the first time that they have to be compliant won't really be January 2017. They've already had, over a period of months, been kind of nudged in the direction of compliance with our new regs, knowing that they were coming. We didn't know for sure whether everything in those regs were going to be enacted, but we knew pretty much the bulk of what was going to go into effect.
Some of it, like, I think one of the things we heard at the committee meeting is someone has signed a 2-year lease and they don't believe they can get out of
Okay,
that
yeah,
lease.
what happens there?
Right now, we don't have anything in our provisions to address that, correct?
No, right now, if it's not that they're doing physical construction, alteration to the facility or physical environment, there's no delay in compliance.
So somebody that would be in that situation that cannot comply they're gonna get fined and everything because they can't comply.
Well,
And there's
perhaps they
no-
shouldn't be compounding if they can't meet the standards. I mean, the board was pretty clear that the standards need to be done. I don't know, that's gonna be one of the harder questions where you're in a lease situation.
Yeah.
You can't move for a period of time. You want to compound, but you're doing something that runs immediately or just plain strongly against the regs. What do we do as the regulator?
And there's no, I mean, we've been at this, what, for three years, is it? That we've been writing these regs? So it's been, everyone knows these are coming. I mean, this should be no surprise.
Earlier this week, I received a letter, it was addressed to me, it was an email actually, that I shared with the board president. I didn't share it with everyone here. I think I asked for it to be brought to the meeting, but Laura was out, so I don't know whether or not that happened. In any event, they requested a 5-year waiver for hazardous drug compounding for construction. That letter, I thought initially went to me, but in checking with other executive officers that I was with the last couple of days, that letter went to everybody. So what they're really requesting is a delay in implementation of USP.
That was a national organization,
was
though.
for
It wasn't,
national
it wasn't a pharmacy, and
No.
it wasn't, I think it came from. the
ASHP.
APHA.
APHA was one, there was one, I think, physicians group on it.
And I think it wasn't to our regs, that letter, it was
No.
to USP 800.
Right, it was-
Basically saying, we need you to hold off on implementation of USP 800 because there's a lot that needs to happen with it. And it went out generally across the country, and it wasn't a pharmacy.
It wasn't just to, it wasn't just to the board here. No one else was entertaining the 5-year waiver, by the way.
Victor.
Right.
I want to make something clear here. So if a hospital right now is doing sterile compounding, and they do need some structural changes to the location, could they still be doing the sterile compounding right now until
Yes.
the new construction
Yes.
is done? So that's what the waiver is
Yes.
for, right?
Right.
But they still could do the compounding at the old location until the new place is all set up and inspected?
As
They
long,
may have
as
to
long
buy a
as,
box.
as long as
Right.
we approve the waiver, because the waivers are gonna come before the board.
And they will
Yes.
come in for waiver to the board. Am I clear?
I think I would defer back to legal counsel on this because, and I think it's going to come to you guys when it comes to that, because to me, it's a question. I think that's definitely in the best interest of the patients to allow that. But if you read how the waiver was written, when I read it, it's to allow them to do construction at the facility. It's not to allow them to do construction of a new facility. So I think that's one of those things I need guidance from you, because I don't know where you're thinking about that type of subject, because there's a lot of little nuances like that I don't know. You guys will have to tell me what you want.
Well, there could be a case where they cannot modify where they're at in order to meet this requirement, and they're gonna have to move to a new place.
And that's kind of what Mr. Law was referring to, is, to me, that's very similar, the lease issue, but they can't get a waiver at that facility because they'll never be able to do the construction. But then, do we allow them to continue to compound under some form of waiver? Well, to me, it's very similar of allowing a hospital to continue to have that delay in compliance where they build another facility. To me, they're very parallel. But that's ultimately going to come down to the decision you guys make, so that we know what you want.
I think what happens is we start seeing these waivers, we'll start getting a better feel for what are the kind of requests that are coming out, how long it's taking. So if one hospital says it's going to take them a year to get something done, another one says, I need 5 years, it should start
that's
norming after a
unreasonable.
while. Yeah, and then we're
5
going to have
years- 5
OSHPD.
years is unreasonable.
No, but we're going to have OSHPD involved, because
that's
they're,
right.
Part involved, it takes longer.
no, OSHPD's
No,
going to
they're
be
saying-
part of our group. We
Yeah,
pulled
but
him in.
They've offered to be
So-
part of it.
I guess maybe that's where I need more guidance. We have a lot of people that are ready to start sending documents and information. How do
They
we?
need,
Yeah.
we've got
We need
a
to know how
form
to do
set
that. Mm-hmm.
up, but Laura, we have a meeting tomorrow where we're going over the form.
Fabulous.
Can we bring that form to the October board meeting?
Oh, it'll be done before then, but
Okay.
yeah. I'm not
Let's,
sure, do you want us
maybe,
to wait if
you know
we
what
get
I'd
my
recommend is, let's see if we can get this form together and then put our compounding group again together, which was Alan and I and yourself and me, and who else was that?
Josh, me.
And Jenny, and then
Michael.
look and see whether we can work through that and then bring it back to the October meeting.
And then I would also say that I'm expecting at least 800 of these waivers, so we're gonna really need to work pretty darn quickly.
Yeah.
Well, I have 1,000 licensees. just,
Yeah, but only 900 of them are in the state.
yeah, but that's the other question, is the waiver process carrying over to my NSCs? They have to meet our same requirements.
Yep.
So I'm getting questions from our NSCs that I need direction on how we want to start collecting this data so we can start analyzing it. I don't see that the waiver process is going to be non-labor intensive for me. And I want to be able to present it to you guys in even fashion, but if you think about it, if you guys want to review each and every one of those, even if we get 300 waivers, that's a lot of time. So I really want to start kind of moving that pretty quickly forward, because people really, the licensees really want to know what we need from them.
Well, and one of the things we're specifically asking, what do you intend to do during the interim while this construction waiver is pending? What do you intend to do? Are you going to continue to compound products, sterile compounded product? Are you gonna do hazardous drugs? What are you gonna do? How are you gonna modify your practice perhaps?
Well, that's something that we need to include on this form, so that
That's
we.
one of the questions that's on the form. Yeah.
So, just to be really clear, and I want to, we don't want to overstep the board's wishes. Do you want to circulate, this is, whatever form is developed is not going to be a required form, because it's not part of the regulation.
Just suggest.
So, do you want to, I understand you want to see the work group, see the form and provide feedback to staff, which you can do. Do you also want it to go to the full board before it's released to the public? Or
What does
just
the board think? I mean, we don't
mean,
have much
I
time, is the
think-
problem.
Yeah.
I mean, we've got, January 1st is right around the
You're
corner.
talking about the request for.
Here, I've
a-
got a
The
copy.
form
I've got a
for a
copy
waiver.
that's sitting here.
What I guess what I'm saying is I may have misheard something you said, and I just want to make sure, because I think from a staff perspective, we're thinking, we want your input, we want to do it, but this is sort of going to be a living document. So it may look like something in October, and it may look like something else in November, depending on what you start getting, but that's okay,
That means
exactly.
we're learning, I hope.
Yeah.
I would hope we wouldn't
putting
change
the
it that
best
much.
But not, not
Yeah.
significantly, but.
No, if there's
it's-
follow-up questions, you can always
right.
reach out to them.
But we're not asking for construction plans. We're not
No.
positioned to look at architectural drawings and things of that magnitude. And if it gets to that point, OSHPD's gonna have to be brought in.
Well,
So-
But given, all the different bodies that, especially for a hospital to get something redone or built, I mean, talk about, a time frame. It could take years.
We recognize
Yeah,
that,
could
but that's
take
part of
years.
why we're gonna track into what OSHPD's doing,
Probably not
because
5 years.
that's the agency that's charged really with overseeing the construction, and we know that they're moving forward according to plan when they're doing that, as opposed to just dealing with the Board of Pharmacy.
The reason we brought them into Stan was
I think it's
a lot
brilliant.
of times we'll hear back is, and I hear this all the time, OSHPD's delaying our plans. You always blame the state, and OSHPD's doing
just
this.
did it.
This
Victor
way, if
just did
OSHPD's
it.
right there, they can't be any more shifting the blame because they're part of it.
They will come to the meetings?
Yeah, he's part of the group.
They seem to be returning my phone calls still,
Okay,
so
good.
we'll see.
So on slide 3 of the
Okay, you can't
PowerPoint,
call.
I mean, it does say, is there architect, are there structural modifications, building plans, building permit? So, I mean, are those really,
That's what I think Alan and I need to take,
Okay.
take a look at.
Yeah.
We're just, what do you need to do? How long is it? What are the obstacles? What are you gonna do in the interim? Who's the architect? We asked about 6 rules.
So
20
what does the
questions.
board think if Alan and I could work with staff and Laura and see if we can get something out as soon as possible, and then we can always, and have it send it out, and then move forward?
Do you think bringing BJ into this?
It's a great idea. Great idea. We
She's
can-
already kind of setting up her own group on their side, so.
Okay.
We can just float it past her and see what she thinks, yeah.
It's a good idea.
Yes,
I'll make a motion.
okay,
Well, actually, go ahead.
go ahead.
You said
Oh,
it's
to
already-
allow, to have Dr. Shad and I work with the staff to develop a recommended format that we can distribute to stakeholders so that they understand what the waiver process is what's being requested of them.
Precisely.
Okay,
Well done.
I'll make it second it.
all right. Public comment.
So were you the motioner? I guess.
I was actually doing it for Ricardo, but I guess I'll motion it.
Oh, easily fixed.
Good afternoon, Brian Warren with California Pharmacists Association. You have to beg my indulgence. I do have a number of questions on the waiver process as well as some clarifications to the regulations themselves. On the waiver process, do you have an anticipated timeframe for when you would release further details about perhaps an example form or further information on what specific requirements will be required for a pharmacy that is submitting a waiver? Because pharmacies that are starting to make some of these changes, starting to look into this, are going to be very, very nervously right now looking into what they need to submit. And I suppose the same could be said that the board has had since April to develop this form, so we
It's
still
on my
don't have
computer,
one.
I'm staring right at it.
The pharmacies have had since April, since a year to also look at the draft regulations. So it goes both ways, Brian.
Well, I know, and that's what I'm
That's
saying.
what
It goes both ways.
I was definitely hearing that.
So, I mean, is there an anticipated time frame for this?
It depends on how quickly we can pull together the team, because what we don't want to do is do a couple of false starts. We have a meeting already scheduled with Laura to go over things of this magnitude. This is one of the things, and it truly is done. I did it Monday, so it's completely, Christine worked from my draft, and so we've already been back and forth. So now we need to bring in the higher level, the 2 board members, and then bring the rest of the team in, so that we don't start with one place and then go, well, here's a revised form, fill this one out, here's another revised form. We want to really do as much as we can with the first iteration. There may be some additional things we need to do, but the questions, that PowerPoint that was given at the enforcement committee last month lays out the general parameters. So if you get a copy of that PowerPoint, you'll have the general parameters of what you're going to have to turn in.
Okay.
And it's intended to be straightforward and easy, Brian. It shouldn't take an architect to have to complete it. It's not going to be that technical.
That's helpful.
And it's also not going to be required.
The form itself,
And then
correct.
there's that.
Recommended, we'll just put
Recommended.
recommendation.
Highly, highly recommended. Yeah.
I think it's called a guidance, learning from the FDA, guidance on applying for delay in compliance for construction.
And then, who, will it be board licensing staff, board inspectors, or who would be reviewing the waivers when they are submitted?
Initially, it's going to be the board, because until they give up the project to staff, I think that we'll have at least 2 board members probably pretty heavily involved.
Okay, so it would be the board members themselves.
2, yeah. Any more
Okay.
than that becomes an issue.
And then,
That's not determined yet. The board hasn't done that.
No, but I looked at the president, I figured, I don't think staff, no, this is a
No.
policy area where I think that the board needs to lay out some direction. And
Agreed.
it says the board or its designee in the staff,
Yes.
in the regulations.
Absolutely.
I just would think it would be a good idea to have the stakeholders at the inspector side just to take a look at them and say, hey, I see this red flag, be careful of that.
The way I see it being most efficient, and I'm pretty much all about efficiency, is myself and or one of the other inspector staff sits down with you guys and we work through 5, 10, 15, 20 of these, and we get a general sense of what you guys would want us to do, and then we can run with that. And then if there are issues that we run into, because everybody's going to have their own special issue, that we can go back to a key 1 or 2 people, and then we can keep this ball rolling, because it's really going to have to move pretty quickly.
I agree. I think that's a great way to do this. Any other comments, Brian?
well, I
He's got a whole
believe,
binder full of questions there.
I
Look
mean,
at
will
it.
the board, and I suppose this could wait, but is there some expectation on whether the board will be wanting pharmacies to be submitting a specific time frame with which they are requesting the waiver? Is it until completion of construction changes, or is it going to be, are you expecting people to be asking for a projected completion date specifically? And if so, what happens when, or if that there's anticipated completion in March of 2017, but then that gets pushed back because you have delays in the construction, or your architect has to redraw their designs?
Let's hope not any of that occurs.
Have to come in for a modification.
But here's one of the questions, and there's 5 parts. A description of the status of the construction process in the pharmacy. Is there an architect? If so, who? Is there a structural modification? Is this a structural modification?
That's what I was talking about, I think that's 2.
Have building plans been developed? Yes or no? Has a building permit been secured? And the timeframe for completion of construction. That's pretty much it. And then we ask a couple more questions that if you're OSHPD, if you're a healthcare provider that would have to use OSHPD, we want the project number and the project, let's see, it's called a project completion timeline and general OSHPD project number. And that way we can track it online as it moves through OSHPD and they won't have to do anymore. That's all online, and we can monitor the progress. So once they're in the OSHPD system, the system becomes a lot easier.
Yeah, for community compounding pharmacies, they will not be in.
Probably not, but they'll use those 5 questions up above, and that's the kind of general information we want. What do you have? How long is it going to be, and where are you in the process?
Okay.
So I have a question, and I guess this is to Christine and Laura. At the last enforcement committee, we had all these FAQs, because when we went through the sterile compounding regs, one of the big things Alan and I came up with is there's a lot of guidance, just from the feedback we were getting. There needs to be a lot of education. So we did, and I think, Christine, you did a good job on those FAQs. Where are we with those? They were supposed to be issued? Have they been issued yet?
I edited them the next day, and they went up for review. I don't know after
Where
that.
are they now?
I believe they're with Laura.
They're
I've got,
part of our agenda for tomorrow, too.
yeah.
Okay, so we need to get those issued, because I think that'll help with some of the questions you're getting, especially as we've issued the new regulations.
We also have a pending self-assessment form, which I'm not sure where it is for compounding, which will also help.
So just for those that weren't, when we looked over all the regulations and all the public comments, we saw that there were certain areas, while they didn't affect the regulations, they were areas where we believed, at least Alan and I did, that there needed to be some clarification so that the stakeholders would know how to move forward. So all of those were assembled into a big list that Christine took and did FAQs for, so that we can help with that guidance and help educate. And that's what I'm talking about. I think she did a really good job on them.
So I think
Okay.
the other areas where we had some questions had to do with the compounding of hazardous drugs. There were some specific provisions in the regulations that dealt with both sterile and non-sterile compounding of hazardous drugs. And I think one of the areas that have been, this has garnered a fair amount of attention among compounding pharmacies throughout the state more recently, because the definition and the regulations of hazardous initially specifically called out anti-neoplastic drugs identified by NIOSH. And of course, NIOSH has 3 tables of hazardous drugs, the anti-neoplastics, and then 2 other tables of non-anti-neoplastics. The absence of reference to those other 2 tables, many pharmacies had assumed meant that they weren't going to necessarily be considered hazardous as treated by these regulations. And there had been subsequent communication that the language regarding any other drugs deemed hazardous by the PIC, there would be an expectation that there are many drugs on those other 2 tables of the NIOSH list that ought to be considered hazardous. And so as a result, there was a lot of sudden, and by sudden I mean within the past month or so, focus on this by non-sterile compounding pharmacies that never previously thought these were going to apply to them. So one area of clarification, and I've been talking with Dr. Acosta kind of offline, and I think that we've had good conversations about this, but one thing that we did want to bring to the board as far as what the board's expectation is here is USP 800 allows for pharmacies to do a risk assessment where they can say that based on their, they can do a process validation, I think it's process validation, where they can look at their compounding of a drug that may be on one of those NIOSH lists, but based on the procedures, the process they're using, the PPE they're using, the engineering control they're using, that there is no risk of contamination. And USP 800 for non-sterile compounding does allow a pharmacy to say, we deem this to be non-hazardous in this specific process. So, and this, I think, specifically comes into relevance with some hormonal compounding. And is this board going to take a similar outlook for pharmacies in terms of doing a risk assessment consistent with USP 800, so that for certain drugs, although they may appear on that NIOSH list, you don't have to do the full-blown USP 800 or negative pressure room for something that has controls in it?
So, and I'll let Christine answer that, but I think one of the questions I would have is, what's the difference between doing a risk assessment and having the PIC identify what they consider hazardous? I mean, I kind of see those as very similar, because you're looking at what you're doing and what you have in place. I don't see a big difference. Christine, what do you think? How to answer that?
I guess I would just try to clarify first. So USP 800 asks for an assessment, but requires all drugs on the NIOSH lists, all 3 lists, to be handled as hazardous drugs. It says an entity must maintain a list of HDs, so hazardous drugs, which must include any items on the current NIOSH list that entity handles. I don't think 800 allows for the exclusion of any of the drugs. I feel like our regulations are allowing that more so than anything else. I think we allowed the pharmacist to do that risk assessment, and if they do it well, then they can determine based on their PPE, based on their handling, based on their contamination, that they aren't. So I feel like our regulations actually allow the pharmacist to use their professional judgment in determining how they handle and use a hazardous drug that NIOSH determined, whether it's hazardous in their facility.
For non-chemo drugs, I mean.
Of course.
Yes.
When I talk about that, I'm saying non-anti-neoplastics. I feel like we were we did a lot of conversation about this, and I feel like we were more gentler and more understanding of what we could do in California to protect the patients but not hinder the practice. I think 800 is coming and there's nothing anybody's going to do to stop it, but we allowed professional judgment so it didn't cause such a huge problem in the practice setting.
You know, I've got a question
Yeah.
about that, and it kind of pertains to this second table. You know, there's a lot of common drugs on here, you know, Tegretol, Dilantin, PTU, Risperidone. These are, and these fall on table 2 that meet one or more of the NIOSH criteria for a hazard drug. And so, you know, these are pretty commonly dispensed items. And the balance between safety and practicality, you know, if I saw this list, I would be scared of regulatory compliance. So, well, and any arena is going to have these drugs in it. So, is that what you're speaking of, Brian?
Well, what I'm speaking to is in the USP, it does say an entity must maintain a list of HDs. It then says which may include items on the current NIOSH list. And then further down, it says any anti-neoplastic HD must follow the requirements in this chapter. And
Okay, that's
then-
the first table.
And then dosage forms of other hazardous drugs on the NIOSH list, the entity may perform an assessment risk to determine alternative containment strategies and work practices. And those alternative containment strategies may be for certain drugs that are on the NIOSH list that when treated with a certain procedure don't need the full requirements of the Chapter 800, with the main one being the negative pressure room, because the risk of exposure has been mitigated by specific procedures that the pharmacy has performed a risk assessment for and determined that the risk of contamination is low or, you know, low enough that they should not be deemed hazardous.
Agreed. So we're saying the same thing. We're just talking about different sections of 800 then. So what he's saying is even though NIOSH may say that is a hazardous drug in one of those categories, if you look at how it's being handled, like you were saying, if they're commonly dispensed drugs, it may not need all of the protection and all of the room requirements needed in 800.
Well, right.
Yeah.
But what I want to make sure of is that the public can indeed get the drugs without too much regulatory bureaucratic burden. And so I want to make sure, while we're in the business of public protection, there's some common sense involved in the enforcement of it.
And I think it's the common sense and the enforcement of it that we're looking for, as well as the clarity, because USP 800 does lay out a little more detail as far as, you know, if there's a drug on the NIOSH list that you're not going to deem hazardous as far as what you're doing with it, you have to perform a risk assessment. The regulations just say, in the PIC's judgment, which is less detailed.
Right.
So looking at the USP 800 procedure for performing risk assessments as something that provides at least greater clarity to pharmacies that are in this situation, and not, you know, because if you don't have to construct an entire negative pressure room for certain compounding, that is a very big difference, and also could mean the difference between this board receiving several dozen waiver requests and, you know, the full 900 waiver requests from all 900 compounding pharmacies.
So if I'm a PIC, and I still don't quite understand this, if I'm a PIC and I do my assessment per what your understanding of 800 is, and I determine that that's not a hazardous agent, then I basically have said that's not, I mean, I'm talking about non-antineoplastics, then I wouldn't include it on my list, and I would have some justification for that.
Correct.
So
And
aren't we kind of saying the same thing?
I
That's
think
why
we-
I'm kind of
I think
confused
we
why that
are.
wouldn't
It's-
cover that.
I think we are, it's just
I want to make sure it's clarified.
the
Yeah.
the clarity from the board that we're kind of in agreement here. Because, I mean, you know, I think the agent is still hazardous, it's what the pharmacy's doing with it,
Correct.
that where that hazard has
Correct.
been mitigated.
Yeah, I think we are. I mean,
Right.
Christine, do you see any issue with that?
No, I think that we could have made it slightly more clear instead of saying in the professional judgment of the pharmacist, we could say something to the effect after a risk assessment is performed by the PIC, something to that effect to kind of use more of the 800 language. But I think that's what we're asking them to do. We're allowing the PIC to use that professional judgment to determine if the product and the form and the manipulations being performed are considered hazardous. And I feel like we gave the California pharmacists a little bit of a leeway when we wrote this, but I think because it kind of grayed up the regulations, it's really been a sticking point for people, and pharmacists tend to like black and white. So I think it's been really hard for them to understand what we mean.
And one of the things that we're trying to do is build some guidelines for our members so that they can feel more comfortable and compliant with this, and part of the clarity that we're seeking now is for our own, for the benefit of doing that.
And that's our goal, too. I think there needs to be some feedback back and forth so that it doesn't happen, because we don't want this to be a gotcha type of thing where they're going in and saying, well, you didn't do this, this, and this. We need to work together and make sure that the understanding's there.
Thank you. Also on the hazardous, there is
May
some.
I make a recommendation? The board actually has a motion on the floor, and it's pretty specific, and not that your items can't be discussed under this agenda item, but I think maybe focusing on the particular motion that's on the floor right now, if there's any comments about that, resolving that motion, and then moving on to sort of the other items that are under generally agenda item 9. Just because that way, if you need to take further action based on the comments that you're receiving, then the
Okay.
board can do that.
That's a good point,
A little bit
Laura.
more organized.
Do you have any other comments relating to the pending
To
motion?
the waiver itself.
So the motion that's on the floor right now is to authorize Dr. Shad and Dr. Gutierrez to work with basically staff to help develop the waiver process and review the sort of the sample form that will be made available to the public.
Are there any comments regarding that, Brian?
I have another one related to, and yes, I think so. So,
Regarding the motion that's pending?
yes.
Okay.
So, it's been discussed, I think, before at one of the board meetings that USP 800 for non-sterile hazardous drugs allows the use of redundant HEPA filtration instead of external ventilation. However, the board's regulations did not allow for that, and there is a big difference there, which I think the board has acknowledged and said this is something that can be cleared up with, you know, follow-on regulations. However, is there any way for this waiver process to make an allowance or to deal with that through this waiver process, I suppose? Because this is something that until, I mean, come January 1st, those requirements will be in place. And even if the board were to file rulemaking tomorrow, we're still gonna be looking at a pretty extensive period of time during which this would not be allowed. So is there a way to deal with this, which is kind of an acknowledged difference and one that is significant, so that those pharmacies aren't in a bad situation? Because, I mean, even some of those pharmacies who've been more proactive at trying to be compliant with USP 800 have already purchased those redundant HEPA filtration hoods, which are $20,000 or so a piece. And then now they're saying, okay, well, these regulations might not allow you to use that $20,000 piece of equipment.
And you're talking about non-sterile.
Correct, non-sterile hazardous compounding. So I don't know if there's any way that, and, you know, maybe it could be discussed outside of this specific motion, but I think because part of the question is whether or not this waiver can address that problem is why I'm bringing it up now.
So the waiver is specifically to physical alterations, so I think,
Physical, yeah,
you know,
very specific.
that's a specific, fact-specific, I don't know enough about HEPA filtration to know if that's
He's
gonna
regard-
be
he's regard-
warranting.
It would fall in there.
Yeah.
It
I was
requires
talking about, well, that's an equipment.
Well, that is equipment, that's not
Well,
structure, yes.
It's requiring physical construction or alteration.
But
Well,
the-
that one.
Well, it's
that's in-
preventing. They don't have to do the physical construction because they have this redundant.
That's what I was thinking. If
Yeah.
it's something that you guys would want to do to move forward and put this at some point into the regulations, we could look at it from, we're allowing them not to do the physical construction.
Yeah, I think
By
that's-
doing this,
I would think
but-
that's appropriate as long as it's for the non-sterile.
But-
I mean,
but-
that's what we're talking
But
about.
here's the thing,
I'm
Amy.
okay with it.
Yeah.
The issue is they're gonna have to externally vent those rooms anyways. So a lot of what we've been hearing is they want the redundant HIPAA filter so they don't have to externally vent the box that they're compounding in, a biological safety cabinet, whatever. They still have to vent those rooms. So are we going to allow a waiver-ish process for the redundant HIPAA filter and then an additional one for not externaling the room? This is where I have to defer to you guys. That's what I think it's.
So I think
It's
those
questionable.
kinds of the questions are going to be best presented on a fact, case-by-case basis. So
Okay.
once you get those requests, I think you'll be able to deal with them. But I think right now what we're talking about is just simply this sort of process and form that, you know, the motion right now is simply to basically
Staff.
delegate the authority to Dr. Gutierrez and Dr. Shad to work with staff to sort of come up with something that we can use. And I think maybe the next conversation is, when you start getting those, what do you do? But I
Yeah.
think,
I think Laura's right, because as soon as we start getting them, we'll get, and as you stated, and I think you said it very eloquently, we'll start getting a feel for how to handle these. You think so, Al?
Yes,
Alan?
I do, it'll be easier once we have some.
Okay, anything else, Brian?
Not on this motion, so as long as we're allowed to talk after the
Okay.
motion.
Not giving up the mic, are you?
Is there any other public comment in relation to this motion?
Good afternoon. My name is Ken Shaw. I'm a pharmacist in charge and director of pharmacy at Sharp Grossmont Hospital. I would like to offer my services to the group that's developing the form to give some public feedback as you move forward to maybe help clarify some of the things that might be going through the heads of directors of pharmacy for this waiver process. Thank you very much.
Thank you.
Thank you.
He just wants to have the first waiver, that's all that is. You're-
Paige Talley with California Council for the Advancement of Pharmacy. The acronym is CCAP. I can do that from now on, hopefully. It's easier. Laura, you may correct me. I think this falls under this category, but I brought it up on August 31st, and again, I have a member, maybe two members, who are in leases, and they expire November 2018, one of them. And the current landlord refuses to let her punch holes, in this particular one, punch holes in the wall. She's looking for other spaces, hoping she can get out of the lease that she's in. You know, I mean, she has an attorney. So, but she may need more. It takes time to find these places, and and time to get out of this lease. So is that a possibility to ask for a waiver? She's non-sterile.
But this was the example Dr. Acosta gave, where basically she's not trying to remediate the facility she's in. She's looking for a way to be allowed to do something until she finds a new location. And that's not really a construction waiver.
Okay, so I'll bring it up after
Yeah.
this. Okay.
Thank you. Any other public comments related to the pending motion? Okay, all in favor? Okay, Brian, you had other comments relating, we'll bring you back up.
Yeah, me and my binder here. That's why I made a binder, because last time I was like that. So I think one of the other questions that's come from our membership with relation to, how to begin planning for compliance with these regulations in January is whether or not the board will accept published literature in determining a BUD for specific formulations, or is the board going to
Say that again, Brian.
whether the board will accept published literature in establishing a BUD for a specific formulation, or is it going to require an in-house study for all BUDs?
I don't think this is on the agenda, is it?
Well, my concern is that it's more of it's on enforcement end, and, I think it's very specific. I mean, to the extent that it's addressed in the FAQs, then we'll deal with that. I mean, I just think this is kind of the wrong, I'm struggling with the forum of the board as a whole giving advice about things that ultimately probably,
Well, I think what we're trying to do is prevent enforcement by
Right,
getting greater
right.
clarity.
But maybe, so maybe the request is that an FAQ be addressed to deal with this issue. What I'm struggling with, I think, is this is a very awkward forum to be trying to resolve the concerns. Does that make sense? Where the regulations need to be reviewed and looked at, and staff may need to talk to the inspectors to get the pharmacy professional judgment perspective and those kinds of things.
Laura, could they ask just some questions, and then we can consider them for FAQs?
Right, that's
we
what
do
I'm
that,
wondering,
Brian?
if maybe that's how we handle your questions, like you would like FAQs that address these issues?
Yes, sir. I mean, yes, we very much would. However, again, I guess the time being of the essence is our main concern here, and why we're bringing them in this kind of awkward type of forum.
Right. Because you're not sure where else to do.
Okay.
Yeah.
What do you mean by published literature? Because there's a lot of bad published literature.
Are you looking like King's or one of the reference sources?
So there is published literature, and I suppose there could be bad published literature.
I know, I the thought.
But I think there's been questions as to whether or not each pharmacy is going to have to do their own in-house study when establishing BUDs.
So I think that is exactly the question, is can somebody else's stability study be my own? And we do have a section in the pending regulations that specifically address that. Laura, if I can read it? Okay. 1735.2I4 says, in addition to the requirements of paragraph 3 is the extension of the BUD, the drugs or compounded drug preparations tested and studied shall be identical in ingredients, specific and essential compounding steps, quality reviews, and packaging as the finished compounded drug preparation. So that's where we're alluding that if they meet that criteria, it may be possible to use somebody else's study, but they're going to need to meet that require. So the answer is yes and no.
Okay.
Perfectly clear, right?
Yeah.
The lawyer's favorite answer. It depends.
Thank you. And another one, I think there's just two more, that is, again, one where this actually does have to deal with potential physical changes to a pharmacy and how they try to determine compliance or take any steps towards getting into compliance by January. And it has to do with the conflict between what's in statute for sterile compounding and what's in these regulations for hazardous compounding. And Christine's nodding her head because she's aware of this as well. where the BMP code requires all sterile compounding to be done in a positive air pressure differential room, and the regulations require all hazardous compounding, which includes sterile hazardous compounding, to be done in a negative pressure room. And I understand the reasons for the positive pressure room for sterile and the negative pressure room for hazardous. However, you cannot be both positive and negative at the same time. So I think what we would recommend is that the board enforce the regulations, as that's consistent with USP 800, and 797 now just defers to 800 as far as how to deal with sterile hazardous compounding. But it is something where pharmacies, because if you're going to need to make a physical change, pharmacies are going to need to know what this board is going to expect pharmacies to be doing on January 1st and whether or not they need to change the air pressure differentials or make any construction changes between now and then, or perhaps submit a waiver.
A lot of smiley faces over there.
Yeah.
So I just say, all these, we just probably need to have these FAQs or these questions come up, and then let us get a chance to take a look at them.
Yeah, I kind of.
You know, yeah, we need some,
Yeah.
And that way we share them more publicly, and we've got a meeting of the
Well, and you can
minds.
think about them and,
Yeah.
yeah.
I kind of see this FAQ, the first draft we just looked at, is just the first draft. We'll be modifying and adding to it, because the whole goal, again, is not to play gotcha, but to help improve and elevate the practice for pharmacy in our state.
And that's absolutely what we want, as far as, pharmacies being crystal clear on what they are expected to do. I just think, again, as far as if a pharmacy is going to January 1st, have to be complying with a statute and regulation that conflict with each other, that's, again, I guess, stressed, just the sooner that they can have clarity, the better, because these are things that may, depending on how the interpretation of the board is, require physical changes to be made at the pharmacy.
Thank you.
No, you
Anything
got
else?
another
You have
one.
others?
You have another?
I did have one more. It's
One
very
more,
similar.
just one more.
It is, and it is, again, a similar type of situation where there, BMP 4127.7, again, requires that all compounding be done in an ISO Class 5 hood within an ISO Class 7 clean room. However, the regulations do define an anti-area, which can be ISO Class 8 or better, which can include staging components and other high particulate generating activities. And we wanted clarity from the board as to whether or not this is allowing for pre-sterilization procedures to be performed in the anti-area, which we would agree is a good policy. It's consistent with the FDA guidance on insanitary conditions, which is a later discussed document on the agenda. But it did not seem clear in the regulations what the board's intent was as far as allowing some of these to be, the pre-sterilization procedures to be performed in the anti-area.
It's like a good question to submit.
So we will submit that as well, but wanted it on the record for today.
Good.
Thank you.
Thanks, Ryan.
While we're going down this road, do we need to amend the BMP code, though, to remove these inconsistencies, so we're not having these conflicts between our more recent regs and a 10-year-old statute?
Yes.
I think that'd be a very good.
Well, why don't we
I
bring,
thought
why don't we bring those
They
provisions?
weren't in our regs, I thought. is
I
what
don't
the
think,
issue
we did,
was.
we modified a couple provisions, but we didn't modify those out. I think one of the things we can do is bring that to October as proposed legislation for next year in an omnibus. It would seem to be an omnibus provision. It's just bad to have bad laws sitting out there that you're not going to enforce. Christine, we're gonna say something, you sure look like you were ready.
Yes, we need to change 4127.7, and then we need to address the building code of 1250.4, section 5 particularly. They're verbatim the same thing, and they conflict with CGMPs, and they do conflict with our pending regulations.
Well, that
So,
unfortunately is
yeah.
not so easy, because that's a 3-year process in year 1, and it's a sequential.
Yeah.
Year 1 just went by.
Yeah, but I think that we can probably, with appropriate legal counsel, find a way to work around the building code but I don't know how we work
Oh.
around the business, well, because
building
it's
code is a reg.
incorporated, it's incorporated
but
into
it's every
17.
year.
Stat-
But they only
Statute,
do
but
it
the
every-
statute will trump a reg.
Yeah.
Change in
So-
statute
but
will
if
trump a
you put it in
reg.
the statute and it modify, and you have to modify, you go back to the legislature.
Is it easier to remove a statute? Can we just get rid of
We
4127?
can talk about that, so.
Yeah, we'll find the option
so-
to the board. How about
So,
that?
in the discussion of next steps, which is on the agenda item, one of the things that staff will be doing is coming up with means to resolve the inconsistencies. Is that what I hear?
I heard something along that line.
Hi.
Hello.
Okay, Paige Talley again with CCAP. I have several questions, sorry. One of them, and I guess it's for clarification purposes for an FAQ. But one is under 1735.2, uppercase F, on page 9 of 41. And when it's explained that 30 days, this is the BUD, 30 days for water containing topical, dermal, and mucosal liquid and semi-solid formulations. Do you mean when the compounding pharmacist is adding water to that product, or do you, because many of the bases come with water, they have water in them, in the bases that pharmacists use, but they're not adding it to them, but the manufacturers include that. And so are you saying that any water-based base that's used has to be 30 days or less?
A good question to ask for the FAQs. We'll give you the same answer we gave Brian.
Okay, because it's very challenging with.
I would reference them back to 795. That's verbatim 795. The answer may be clearer in there.
USP 795? Okay, but will you still put that in an FAQ?
Yeah, we'll just I think that, you just got the answer to the FAQ, but, yeah.
I would just like to interject. I'm sure the regulations are sufficiently clear. There may be a few areas where, FAQs are needed, but at this point, I think it's important to move forward.
Thank you, Desiree.
Yes.
Any other public comment?
I have more.
Are they questions that you can submit to us for consideration for FAQs?
Probably, yes.
I tend to agree with what Desiree was saying, which is that if what we're
Okay.
looking for is clarification of what the regs say or require, I think the best way to handle that is to maybe
Okay,
request those
I
in
have
FAQ,
several
'cause
that I
otherwise we'll
can-
kind of be here
Yeah,
for a
and
while.
and we'll
I can give
consider
those
them,
to
and
you
if they're
because,
ones that
yeah.
we believe need clarification, we will.
Especially with the feds versus California regs, that too. Okay,
Thank you. All right, moving on. Item 10, which is the Federal Food FDA's draft guidance documents. There are 3 of them that are listed. The FDA has released these regarding compounding, and I think they're still in draft form, right, Jenny? And so one of them actually is really interesting. If you read the name, it's in sanitary conditions. At first, I thought that was a typo. That is,
Everyone's learned a
it's
new
a real
word.
word.
Everyone's learned a new word.
So the FDA notes in each of these documents that the guidance documents do not establish legally enforceable responsibility. They merely describe the agency's current thinking on a topic and should only be viewed as recommendations. At the Enforcement Committee, several of these guidance documents were discussed, which contain proposed elements for FDA regulation. The committee determined that comments that should be submitted on the guidance documents and asked the board staff to draft comments for the board to review and approve at the next meeting. Now, I think some of them were time-sensitive, too, in terms of the.
They're all pretty much are due in the next 15 to 20 days, by mid-October, actually.
So our EO just finished attending the FDA's 50-state meeting on compounding. Ginny, you want to give us an update on what you found there?
Well, as I said when I came in, and if anyone heard me, the FDA has figured out how to put 50 different states in the room and get us to talk. So of the 5 meetings, this one was the first one that really seemed productive to me. I will tell you that the draft guidance is one of the one that they're pushing the most right now is the insanitary guidance document. They are using it. This was in response to something that happened about 2 years ago. California was one state, and there was one other state that got up to complain about what was going on, where the FDA would come into a 503A, which is a compounding pharmacy, and they would hold them to good manufacturing principles, which is what you hold an outsourcer to. And that's a very much revved up set of standards that very few pharmacies, if any of them, can comply with. And the end result was the pharmacy had to issue a recall, retract a bunch of product. Usually, in most cases, they stopped sterile compounding. And we were kind of surprised at one of the pharmacies that this happened to, we had some issues with, but the other was a good pharmacy and we thought was doing a good job. Well, the end result was the FDA came in, they ended up doing the recall, they stopped doing sterile compounding. And California wasn't the only state. So what the insanitary guidelines say are, these are the conditions under which we'll come in and take action against either an outsourcing facility or a compounding pharmacy. That if they are doing things that are on the list and other things that would be similar to what's not listed, but could also mean you've got an adulterated product, they will order a recall. So, they say they're doing it to outsourcers and to community pharmacies. I'm not aware of an outsourcer that's been asked to do this under insanitary conditions. Are you? No. I didn't specifically ask that question, although I did ask lots of other ones. But
Our shy little Jenny.
I know, I was shy too. They actually gave me a microphone for I don't know, maybe 20 minutes. It was more than enough for most people, I'm sure. Where I talked about our outsourcing program.
So do you think that this is something that has been put forward by industry with the idea of maybe limiting the providers that are making the product?
My belief is what we've got here is pharmacies are going to compound, and they want to get to the place where pharmacies are compounding, with rare exceptions, only patient-specific drugs with a prescription in hand. They don't like prescriber office use, where the boards are, or where pharmacies are compounding for prescriber office use, unless you're an outsourcer, in which case then you're held to CGMPs. Now, one of the problems that I pointed out is no one is regulating, can we turn off the tape, please? No one is regulating compounding in physicians' offices. The medical board does not do it. We don't have any jurisdiction in that environment, and the board, or the FDA does not go into physicians' offices and look at their compounding practice. The end result is that the Board of Pharmacy, which currently has a statute that says it can oversee compounding for future use for prescribers, if the board stops doing that, it means that there will be even more drugs made in physicians' offices potentially, because you no longer have pharmacies providing the drugs into doctors' offices, which to me is inherently more dangerous, and it's against public protection because no one is regulating it.
But Jen, in response to that, USP 800, is that restricted only to pharmacies?
Physicians, I believe, can do that too.
But there won't be any enforcement.
Right, but I meant, well, that's our issue, that's our state issue, but USP 800 doesn't say, hey, this is only for pharmacies.
Nope, all healthcare practitioners.
So the question is, why aren't we talking to the medical board and saying, look, here's some new guidelines, we've taken the stand on the pharmacy side, why aren't you doing the same thing on the physician
We actually have
side?
had the discussion whether or not the law even allows physicians to compound. And that's been going on between our attorneys right now, not the attorneys I have in the room, but I have another attorney that's heavily involved. I've had 2 discussions that were relatively brief with the medical board's director, and we are talking about having a group work together so that we can meet informally between board meetings and share issues of concern. This is clearly one for pharmacy, where if the board is going to enforce these standards, it's hard not to see why.
Well, I think it's more than that. There's some federal standards out there, and they don't apply just to pharmacy preparation. They apply to everything. So if that's true, why isn't our state enforcing it in all areas where that manufacture, or that preparation is taking place?
And that will be the gist of our
Well,
conversation.
who would enforce it, though?
It would have to be the medical
Medical
board.
board.
Some states allow the pharmacy board to regulate that. In this state, we don't. Our hands are kind of full with what we've already got to regulate.
Except that's not an area where they have a lot of expertise.
Well, and that's part of the danger. We've seen situations where we have pharmacy technicians, for example, working in a physician's office. They're not pharmacy technicians in a doctor's office. They are just employees. But again, they don't have the training of a pharmacist sometimes. Sometimes the techs actually do the compounding. But some of the sterile compounding requirements that we have, and certainly our regs, are far beyond just something that you decide to get up and do today. It takes a lot of work and prep to do this. The veterinary board is in the process right now of developing regs for compounding by veterinarian offices for their own patients. They're not going to set up pharmacies and start compounding, but they're actually in the process of doing that. And they are not going to allow sterile compounding in veterinary offices. And initially, they had a version of a bill that was actually taking some of our requirements and laying those in for compounding to match ours. So the vet board's trying to match what we're doing. But it's unclear how many physicians' offices are doing it. Certain specialties, you do it a lot more than others. And so anyway, but where the FDA is going, they will continue to use the instability or the insanitary conditions as a means to come into pharmacies and ask for a recall and push for a higher standard. The other way around that, of course, is for us to have an MOU that we sign, which hasn't been developed yet, where without it, they're going to limit cross-state transmission to only 5%. They were talking before at 30%, they have pulled that figure back, and they don't have a current draft of an MOU out there.
If you read the insanitary conditions document, if you look at examples, the number one is vermin. Did you see that? The second one is mold and bacteria.
And they had wonderful pictures that were just absolutely, they look like some that regrettably we've taken in California. One of them was, I have to admit, we had one of our pictures up there and I spotted it. I took one look and I go, oh, that's California. It happened to be a toaster oven with a thermometer stuck in the middle of it. And those of you that have seen the picture know what I'm talking about.
And I think someone, was it Brian earlier who mentioned the hormones? There's a reference to hormones in here as well.
Oh, if you look at the list of things they cite as insanitary, you don't want any of that in your medicine. So, you have to agree that, yeah, they're on the right track, and they're calling things misbranded if they have any of these things. So that will become an enforcement option for us, perhaps down the road, once they finalize it.
Good afternoon.
Good afternoon. I have a question, a point of information question, as I'm Jody Jacobson Wedgwood, I'm one of the pharmacists licensed by y'all. It was my understanding as a pharmacist that the Consumer Affairs Department protected the patient, not us, so to speak. And so the regulations would protect patients. I'm having a little disconnect between why the regulations that are for the patients are null and void if they happen in a physician's office, and why the Board of Medicine would have an option, if you will, not to protect the public.
I think that's a question for the medical board.
Yeah.
I mean-
And I can't answer that question. I would like to answer that question, but I think you're asking the wrong body. Yeah, I think
This
it's
is
good
a sister
question.
board that we in fact actually have a very good relationship with.
Until
And
you
in a
came
lot
along,
of,
yeah.
until this airs, in which case then I'll have to slink out the back door of the office too.
Can she get CE to go to the medical board meetings?
I don't think they give pharmacists CE for going to medical board meetings.
Do they? She could go and ask that question.
Well, there might be a physician in the room if she does. In all seriousness, I don't know whether or not it's a lack of priority for them, something they've never done before, the lack that this is a potential problem, but we know it's a potential problem, which is why we're trying to do this work group where we can exchange ideas and bring them to our board so that we can kind of move forward, as you say, to benefit consumer protection,
Okay,
which
thank
is
you.
all of our mandates.
And I will just share with everybody that as someone who has gone around to the 503Bs and 503As, we are one of the most stringent boards, and
We
you
are.
all have protected us all over the country, so thank you.
Thank you.
I will tell you that we are recognized as a leader, and we get a lot of deference from other states because of it, which is why they give me a microphone to talk.
So Jenny, we had actually also asked that we draft comments for the board to review and approve the next meeting. Do we have those?
No, I have an outline of what I'll do, and I'll give them to you. With the board's consent, I'd like to request the board to approve for Amy and I to work together
On,
on comments
Comments.
for the guidance document.
The ones we
Bring them
discussed
back
at the
to board.
enforcement committee.
okay, now, are we, specifically, what are we speaking of?
The comments to all of these FDA guidance
All
documents.
three of these?
Remember, we discussed at the enforcement committee what comments we should provide to the FDA.
Right, okay, you're speaking to insanitary conditions and also the compounded drugs that are essentially copies?
Right, there's one for outsourcers, there's one for pharmacies.
503A and
There's
503B.
there's two of them.
There was, I thought, were these the only three we talked about? 'Cause
There
I
was,
thought
there was
one.
bulk, there was a bulk drug product that the board didn't, or the committee didn't recommend moving forward with, but if you'd like, we can consider them. There's actually 1, 2, 3, 4, 5 of them out right now.
And only 3 of them we actually have requested comments on.
Jenny?
So
Jenny?
given that it's just Amy and Jenny, and I don't mean just Amy and Jenny, I mean Amy and Jenny, I mean, you would have room for one more board
Yeah,
member.
Alan could do it.
Yeah, I'd like to.
Let's have you
Okay.
Yeah,
involved
so
in
I
it,
would recommend
definitely.
Alan.
The FDA,
Victor just motioned.
the FDA guidance on the bulk documents is no longer in draft form. So we can talk about it, but we can't provide comments, I don't
Okay.
believe.
They'll take our comments.
Oh, they'll take Jenny's comments.
They'll take our comments.
Make the motion.
Second.
Second by Stan.
Okay. Do you want to do, are we doing all of them? We'll just review whether it's appropriate.
Yeah,
first to
actually,
try-
yeah, I think Alan would be good to actually do it. I don't know if you need me. He's
Always
actually.
need you.
He would
Always
he would
need
be
you.
great at
Smart
doing
man,
this.
you're a smart
I'll
man.
send you the
Alan.
guidance documents. But on the 503Bs, one of the things we're talking about there is whether or not you're dealing with a copy of a commercially available drug. And in that, the guidance document is very clear what they stress in there, and I know that we've got somebody here that wants to talk a little bit about it, that one of the things is that if it is duplicating a commercially available product, unless there's a drug shortage, you cannot do it. And that is to protect the manufacturers that have gone through the ANDA and NDA testing for their drug products, and they see that if you go to an outsourcer that's just doing outsourcing, no offense intended the way that was said, if an outsourcer that is outsourcing has not done those stability studies and all the other documentation, and they see it as a real threat upon the drug approval process for the drugs, and hence a negative step backwards for public protection.
And I don't believe that. And so.
Oh, I think I'm hearing a comment. I'm hearing a comment already.
No, I think this is it's an artificial argument. I think that is not for the public protection, and I have serious problems with this. This is something that has been financed and pushed by the manufacturers. This is a big pharma rule, and it goes in the face of the laws and regulations that we are making up and enforcing. And so I see real problems with this. I'm not a go-along guy on this. I'm a go-along guy on a lot of things, but this,
We get a
I
new
think,
board member on this committee.
I'd like to say that Alan and I had same lunch. Same lunch.
They're with the relationship with the FDA is what I'm hearing. Okay.
Oh, good. That's a good thing.
He stood up and said it. He didn't send an anonymous email.
No, that's true. That is true. It's very loud and clear. Okay, then I will send the guidance documents out tomorrow, so then we can figure out.
Get the draft. I mean,
And
our
we-
responses, right, per what we came up with at the enforcement committee.
I think there's a motion on that, right?
Yes, there is.
It's not, there's, yeah.
But we have, there, public
All right,
comment.
public comment on the motion that's on the table.
Or if you want to comment on any of the documents.
Oh, you couldn't hear the motion. Okay. Do you want to repeat the motion?
Motion was for Jenny and dedicate
To have,
the executive director to draft the language?
And to have
to
Alan,
work with Alan and Amy
Yeah,
to draft a
on
response
providing
to the
response.
FDA.
A response.
A response to the FDA on the 3 guidance documents that are listed on the agenda.
somebody wanted to make some comment. Oh, good.
I hope this all isn't about you, Alan.
Hi, everyone. I realize I'm probably standing between us and adjournment, so I'll be kind of brief.
Probably not.
Okay, even better. My name's Andrew Harrison. I'm the Chief Counsel for Pharmedium Services. We're an FDA-registered 503B outsourcing facility, and I think, I believe the gentleman was Alan that was echoing the concerns with respect to the essentially a copy guidance. I think we would only offer some additional clarification is needed based on a fair reading of the guidance as it applies to 503B registrants. I do have just some prepared remarks. I'm not going to insult anyone's intelligence by reading them to you. I have provided them to Jenny, who I'm assuming will share them with you as she feels necessary if she finds that they fit within your comment structure. As most of you are well aware, 503B does prohibit compounding of what constitutes what is essentially a copy of an approved drug, and whoever said it earlier, rightfully so, it is intended to protect the federal drug approval process, or at least that's the stated reason. And that is defined to include a compounded drug that's either identical or nearly identical to an approved drug, unless that drug is in shortage and published on the drug shortage list, or is made from quote-unquote bulk drug substances that are components of an approved drug, unless a prescriber determines the change produces a clinical difference for an individual patient. So the provision that prohibits compounding drugs that are nearly identical to approved drugs and then places additional restrictions on the practice of compounding from bulk drug substances, as opposed to compounding from approved drugs or drugs in finished form. The term bulk drug substance in that instance, in practically all other instances in which that term is used in the statute and implementing regulations, means the raw starting material active pharmaceutical ingredients that some compounders use to make sterile drugs. That distinction favors compounding from finished sterile drugs, which involves relatively less risk in the aseptic process in terms of fewer manipulations and lower contamination risk, which has been recognized by USP 797 for years in the different levels of risk of categorization of compounded products. And that approach, apart from providing less risk, it doesn't necessarily have the same potential to undercut the market for FDA-approved drugs the way bulk compounding from non-sterile powders and whatnot could. The specific issue, now that I've kind of laid a little bit of foundation, is found in lines 278 and 80 of the guidance document, where we believe FDA is incorrectly applying the clinical difference documentation requirement to drugs that are made without any bulk drug substance API, such as those drugs that are compounded using a sterile-to-sterile process to develop the compounded drug product. Under the agency's interpretation, there would be no such thing as compounding without using bulk drug substances. I will just say sterile-to-sterile compounding uses finished drugs rather than bulk drug substances. The compounding often involves preparing in advance a sterile drug for administration in accordance with the drug manufacturer's approved directions for use, rather than preparing it based on unique patient need. For many reasons, hospitals outsource much of that production to 503B registered outsourcing facilities, which prepare ready-to-use formulations under more highly controlled environments than are available in the traditional hospital setting. I'm going to make a statement, and I'll provide a reference for it. Because virtually all compounded drugs used in hospitals are sterile-to-sterile compounded preparations, i.e. those compounded from already approved drugs, FDA's proposal would necessitate extensive new documentation and record-keeping requirements for nearly all hospital-administered compounded drugs. And that statement is taken from the OIG report from 2013, where in 2012, 92% of hospitals used compounded sterile preparation, and of those hospitals that used those preparations, 92% used sterile-to-sterile products, and only 25% had occasion to use higher-risk non-sterile-to-sterile products in their compounding. We believe that the way the guidance is currently positioned, it blurs the line between Section 503A pharmacy compounding pursuant to a prescription and Section 503B outsourcing, which under the draft guidance would almost always require an individualized clinical determination of need or difference. Because bulk drug substances may or may not share an active ingredient with an approved drug, this interpretation would encourage more non-sterile to sterile compounding, which carries greater risk of contamination, as I mentioned earlier. It may even encourage a return to the reliance on pharmacy compounding, which is not performed in accordance with GMP standards, because the documentation requirement would be similar to the 503A prescription requirement. We believe FDA's proposed documentation fails to address the public health objective that's stated in the intent of the statute, which is a clinical determination that a non-sterile bulk substance produces a change from the approved sterile drug that is clinically significant for a particular patient. The lack of enforcement against starting with bulk drug substances when it is clinically unjustified subjects patients to higher risk products and allows compounders to undercut the market for higher quality preparations by offering cheaper preparations made from lower cost starting materials. At that point, I think I'll conclude in terms of my request for support that you actively do comment on this guidance, and would urge you with all sincerity to please review the section of the guidance that I've referred to. We do believe that clarification in that guidance is necessary to effectuate the intent of what we assume FDA had intended, as well as to kind of lay in more concrete fashion a lot of the work that's already been done with respect to bulk drug substances since 2013 and DQSA was implemented. Thank you.
Thank you. Good afternoon.
Good afternoon. Hi, my name is Grace Magaman. I'm from the Children's Hospital of Orange County, and I'm not sure whether this is the best or most appropriate forum to state my comment, but it is also to urge the committee to support perhaps some comments or comments around the compounding of an essentially a copy product. I guess from the pediatric standpoint, and this may be whether it's sterile or non-sterile, and the example I'll give to you today is regarding a non-sterile compounding product, where previously there weren't any commercially available products. The manufacturer has now created a commercially available product. It does not have a pediatric indication. It's intended for adults. However, now that it's commercially made, we're bound by this requirement to actually purchase it and use it and dispense it for our patients. And I understand the importance of all the testing and the rigors that the manufacturers go through to provide the quality and the dating that they do. However, in the example that I'd like to bring to your attention, especially in the realm of patient care, patient access, and public health, really, it comes down to, there's an example for Revatio, which is the sildenafil compounded solution. We used to compound that from tablets, which are pennies, and now one bottle of Revatio suspension for a patient is about $6,000 a month. And when you talk about 50 patients that we care for on a monthly basis, and they're getting 1 to 2 bottles a month, that becomes entirely very difficult for any organization to comply to. It becomes difficult for patients to continue affording, and then they stop taking their medications, which then causes them to bounce back into the hospital. Added to that is the impact from the federal upper limit changes to reimbursement from the ACA, and that is just really destroying what we're able to do for patient care. From CHOC, we are big about obviously taking care of our patients and taking care of them as a whole. And so we strongly believe that we want to do the right thing. We've converted to Revatio, and I have finance obviously hounding me for hundreds of thousands of dollars of spend per month on this one drug, but this is not sustainable. The manufacturers that jump on board and do this kind of production, again, it's not indicated for pediatrics. It creates this environment that is going to shut down pharmacies, or they're going to break the law and do it anyways. So again, I ask you to really consider how to take all of that into consideration and what the patient care impact will be from something like this. Thank you.
Even if the indication from the FDA is not for pediatrics, you still can't use it? You still have to use it, even though they have no pediatric indication?
That is our standard of practice in pediatrics, there are oftentimes no indications for
I
pediatrics.
wonder if that's a loophole you could use.
Well, so we approached that, and quite honestly, some of one of the comments that I got from the state Department of Health was that, well, if it's clinically justified to use it, then go right ahead. You know, of course, the state doesn't necessarily want to pay for $6,000 a bottle when they could pay for $1,000, but. And maybe this is just me being a pharmacist that's black and white. It's not clinically justified. You know, for example, we have lansoprazole that we compound for our patients that are 6 months of age and younger because there's excipients in the manufacturer's compound that they shouldn't have. There's preservatives. We want to protect them from that. So that is clinically justified. But if a patient just doesn't like the taste, we don't feel that we have a leg to stand on, really, if something happens. And so we understand the severity of an error that comes from a compounding mistake. But at the same time, you know, we're just seeing more and more of this come down the line, and especially with the payment structure for children in the state of California. I think, you know, I've lobbied for, you know, to at the state and the national level to see if there's any other involvement from other pharmacies that could help kind of elevate the urgency of this. But it sounds like we're a little bit unique in our situation as well. And so I'm just trying to really escalate somewhere to make sure that our patients continue to get paid, cared for, because we see it on the hospital. Yeah, well, that too, right? We see it on the hospital end, and we want to keep them well and keep them out.
So which pay system is it? Is it Crippled Children's or Medi-Cal or?
It is Medi-Cal, and many of our patients, they fall under CCS, which is the chronic conditions which is basically a subset of Medicaid. But yeah, so we are still fee for service, and I know there's a lot of discussion about going to the managed care model, but you know, we're just trying to keep up with these changes and still, again, do the right thing for our patients and to be able to do that consistently across the board, because we can't say, well, we'll do this for you, Mrs. Jones, but not for you, Mrs. Smith. And, you know, that will just be, that's just not right.
No, it isn't. And there's this whole initiative now in the state of California in this federal program. It's, you know, the same access of healthcare services for everyone. Mm-hmm. And it's an appropriate thing to have in existence. Whether it exists now is being questioned by lots of people.
Yeah, I would agree. And I think, again, just going back to the whole FUL with the ACA, we're getting a lot of people come and because their pharmacies are shutting down, and a lot of patients will say, well, we were told to come to CHOP because nobody else is going to do it. And so, you know, as we see more of this, we need to at least, I need to do something at a higher level and to advocate for my patients. So thank you for.
Thanks, Grace.
Have you tried any other avenues?
Well, I've gone to our Children's Hospital Association on the state and the national level to see if they can get any more feedback and to see what avenues they can put out some feelers and maybe make some movement on considerations for change. Any other recommendations?
Thank you for what you do.
Oh, thank you.
Thank you. Any other public comment? Okay, otherwise, we're going to adjourn into closed session. Oh, we have a motion, sorry. All right, all in favor of the motion?
Thank you all.
Now we can adjourn.